The department tried to verify boutique's claims, and as it mentions in the reconsideration order, that controllable cancellation statistic wasn't something that could be confirmed anywhere. The department doesn't know what controllable encompasses or doesn't encompass, and it didn't have any other evidence of boutique's reliability before it.
Colleagues don't have additional questions? Thank you, counsel.
Thank you, Your Honor.
Mr. Goldberg, we'll give you a minute for rebuttal.
Thank you, Your Honors. May it please the court again, Roy Goldberg. On this last point, I think that's counsel testifying as to the state of the pandemic in 2021, but December was, I believe it was called Omicron, maybe it was Delta. I mean, things had changed quite a bit and it was still a serious situation for the industry. So it's frankly arbitrary and capricious for the department at this time to say, well, we've decided that the community had this overwhelming vote in the matter, and because it was basically an effective debarment, like in government contracts, where they're saying, well, we're not going to allow you boutique. But that wasn't the due process. It wasn't even in the original order and barely in the reconsideration order. So I don't think the government has put on the record a rational basis for how it treated boutique here. And there's no real discussion as to how the numbers really work out and why it's so important to have the much more expensive Denver air connection. And finally, there really is no explanation in the record as to why in Rutland and in Quincy, being a few $100,000 over, even though the community wanted boutique, was sufficient to deny boutique air in those markets, 2017, 2019. And then we come to today where it's a completely reverse. They give lip service to the requirement in the statute, but they don't explain, they don't show their work. So we think it's arbitrary and capricious. It's not the right way to do this program. I know the DOT can do it right. They did it right in Parkersburg, frankly, and that's why we ask for relief from this court. Thank you very much.
And you are not challenging the community preference analysis. You're challenging really principally this extraordinary cost difference.
There's 5 statutory factors.
Yeah, but when you're
right, they can consider community, of course.
But you're not challenging the way they consider community.
Well, yeah, a little bit, Your Honor, because in the order, they don't say anything about past performance. They quote the mayor in a letter saying something without using any emphasis on that at all. And then in the reconsideration, they do bring it out a little bit more, certainly. Talking about 2021, they never tie it up till now. They never talk, other than saying that we don't believe your 99% figure, boutique. So I would think.
They don't say they don't believe, they say we can't substantiate it.
Exactly. I'm sorry. That's what I mean. They can't substantiate it. Exactly. But when they say that the recent history shows a performance issue, I think in this world, 2024 to 2028 is not relevant to December 2021. Thank you very much.
Thank you, counsel. Thank you to both counsel. We'll take this case under submission.
Case number 24-5188, University of Chicago Medical Center appellants versus Robert F. Kennedy Jr., Secretary, U.S. Department of Health and Human Services. Mr. Collins for the appellant, Mr. Lewis for the appellate.
Good morning, counsel. Mr. Collins, please proceed when you're ready.
Morning, Your Honors. May it please the court. I represent the University of Chicago Medical Center, which I'll refer to today as the hospital. And with me today at council table is my colleague, Bob Roth. The hospital has one of the largest resident training programs in the country. And this case involves Medicare's payment for indirect medical education costs, or IME as it's called, things like overhead rather than salary. Importantly, there's no dispute here about the correct amount of payment for IME that the hospital is due under the law. Instead, the dispute here is about whether the secretary should be able to pay less than the correct amount based on by dismissing portions of the claims for alleged lack of jurisdiction. The hospital appealed two components of its IME, the resident count and the bed count. And I'll start with the bed count issue here. It's indisputable that the hospital claimed IME on its cost report. It's indisputable that the hospital claimed its bed on the cost report. It's also indisputable that the contractor audited the cost report and audited IME. It's also indisputable that the contractor audited the bed count and adjusted the bed count on the cost report. And so the hospital's bed count appeal squarely falls into the line of cases stretching all the way back to the Bethesda case, holding there's jurisdiction under 1395 00A. But the cost reports that the hospital submitted contained an irreconcilable conflict. And that is because the hospital mistakenly had included 8 beds, which were from a non-reimbursable cost center that was called clinical research. But the hospital was only half wrong in its submission because it also identified the clinical research center as non-reimbursable and did not receive any payment for those costs related to those. And when the contractor audited and adjusted the bed count for other reasons, it failed to remove the 8 non-reimbursable beds, and that left in place this irreconcilable conflict. The board dismissed the bed count issue, stating it had no jurisdiction under 1395 00A, but even if it did, it would decline to exercise that jurisdiction under 1395 00D based on its past decisions and cases routinely doing so when a hospital fails to claim costs on the cost report. The board's dismissal was unlawful and it was pretty radical. Every court case the board relied on involved situations where hospitals did not claim costs on the cost report. And that's a situation where, of course, the contractor has no opportunity to award the costs, where it's not presented, which is what the Bethesda case talks about. It's never presented to the agency. But in contrast here, the hospital included its claim for IME in the cost report. It included its bed count in the cost report, and the contractor actually adjusted the very item that the hospital later appealed. The statute 1395.
How much does that part of the factual background matter to you? I mean, in other words, suppose that it's undisputed that had everybody been on notice about this bed count issue, then the contractor would have understood that, oh, actually, that's true, it's 8, it's off by 8, we should reduce it by 8, and that will up the amount that you get back, that would have happened. But that wasn't raised to the contractor. It wasn't raised in those terms, at least. Yes, there was information given to the contractor from which the contractor could have made that conclusion on its own, but the particular point that there's an 8-bed discrepancy obviously wasn't flagged. Right, that wasn't flagged in so many words. So if that's true, then is your argument that no matter what, regardless of this other information that was in the record from which the contractor could have drawn the correct conclusion, that the mere fact that there's this discrepancy and everybody understands that there's this discrepancy and that the hospital was dissatisfied with the total amount that it received and therefore levied the requisite action, that's enough, and that then the board at that point was required to make the correction?
Yes, that's correct, Your Honor. I mean, under 1395 00A, the hospital met all the requirements for presentment, and in fact, the district court's decision mischaracterized the record in the district court's ruling. The district court said that the hospital did not present any facts forming the basis of its claim that it operated with fewer than 417 beds. But in fact, the cost report on its face has the beds are identified as from the clinical research center, 8 beds. The clinical research center is identified as non-reimbursable. So the contractor gave the hospital the worst of both worlds. It accepted that it was non-reimbursable, reducing Medicare payment generally, but left in the 8 beds and reduced the IME payment specifically. So that under the plain words of the statute, as interpreted by Bethesda, the the hospital satisfied its presentment requirement of its claim.
So could the agency, is your view that because of the way the statute's worded, that the agency, just period, cannot have a rule that says, if you fail to present a discrepancy in some way to the contractor, then you're out of luck before the board?
Yeah, well, first of all, the agency doesn't have that rule. We believe, in our
No,
papers.
but I'm asking you, could the agency have that rule?
I think that would override 1395 OOA statutory language. I don't think they could. I don't
They
think.
could, there's no way that the agency could say, you have to present an issue to the contractor in order to preserve it before
Well,
the board.
Your Honor, Bethesda said you have to present an issue. And so I think this is very different than the situation where a hospital omits a claim, just completely omits information that the contractor and that the Medicare program could use to pay them correctly. But when the claim is submitted on the cost report, there is an error. When the contractor is obligated to audit and do a decent job providing correct Medicare payment, the Medicare statute has to be read to provide an appeal right there, because otherwise hospitals literally have no opportunity to correct an error made that they make on their cost report, because there is no obligation for a contractor to accept an amended cost report. There's no obligation for a contractor to reopen. That's purely discretionary. That's not statutory. That's something that they offer by grace. So this means.
But if that opportunity is available and it wasn't taken advantage of, then is the agency barred from having a rule that says you had an opportunity to bring something before the contractor's attention, didn't take advantage of that opportunity, and having not taken advantage of that opportunity, it's not something that can be brought to the board?
Well, you're assuming that you have that opportunity. You don't. You hypothetically could you could submit a new cost report and it could be accepted, but that's discretionary. You're not entitled to do that. So you can't, if a hospital makes a mistake, if there were a rule that said you can never correct it, I think that violates 1395 OOA. I don't think that's permissible under Bethesda. And it would depend entirely on the caprice of the contractor. When the contractor reviews the cost report.
No, I guess what I'd be envisioning is if there's an opportunity to present it to the contractor, and you may be right that the contractor doesn't have to look. Let's just suppose the contractor, for whatever reason, gets a corrected cost report that says, oh, by the way, 8 beds are off. This is there's more than $600,000 at stake. Ought to take account of that. And the contractor, for whatever reason, declines to do that. Then the board might be hard pressed to say, because the contractor, for whatever reason, decided not to engage with it, we don't have to engage with it. But it seems different to me to say, for the board to say, you at least have to raise it and give the contractor the opportunity to consider it. And if you didn't do that, then we don't have to take account of it.
And the question is, what does it mean to raise it?
Yeah.
And our position, and I believe it's the correct one, is submitting it on the cost report, demonstrating all the information is there for the contractor to come up with the right outcome. The contractor failed to come up with the right outcome, and that's where the appeal rights come in.
So you're saying that Bethesda says providers who fail to request from the intermediary reimbursement for all costs to which they are entitled under applicable rules, that the failure to request the cost that they're entitled to might establish that they're satisfied. And you're saying that's not this case because the cost amount that you requested was only supported if the intermediary corrected the 8-bed error in the one part of the submission, right? In other words, you requested, it doesn't establish that you were satisfied because it doesn't support the number that you asked for. It being the erroneous bed count in the relevant part of the submission.
Correct.
So you're saying that you couldn't have been satisfied because the number should alert them, together with the contrary treatment of bed counts in where the submission identifies non-reimbursable beds.
That's correct. And
Putting
also
those 3 things together, that yeah, there's an error in the bed count, but elsewhere when reimbursable beds are tallied, it's correct. And the number that the hospital is requesting would only be the correct number if that correct bed count were consistent throughout.
That's correct, Your Honor. I mean, it's a little bit tricky to understand. And really, the statute says you have to be dissatisfied with your total program reimbursement. I mean, that's, the language says that. Bethesda read into that. And actually, that's the dicta of Bethesda. You know, Bethesda was not that case. It talks about presentment, the importance of presenting. That's the key.
Let's suppose that you didn't even raise this argument before the board, right? And then you filed an action in district court. Would the district court be required to adjudicate the validity of counting the beds when it wasn't raised even before the board?
No, Your Honor.
No. I mean, that's clear,
Yeah,
right?
that is very clear.
So, and the reason is we have an exhaustion of administrative remedies rule. It's not written necessarily. Some statutes write it. Why can't the board have the same kind of rule?
Well, the board, Bethesda says that what's important is the
So
hospital.
this is exhaustion. That it may be, as Judge Breyer said, there are situations in which it would be proper to consider it. But nevertheless, as a general rule, the board is requiring exhaustion, and you didn't exhaust your remedy before the intermediary.
Well, I disagree with that conclusion that we didn't exhaust, because the hospital sought its full IME payment. It presented the information to the contractor. It's all in the cost report. So that Bethesda says you must present. We presented. I don't think the board can adopt its own separate pre-exhaustion requirement, because there's nowhere in the statute that would support that. If there were to be a rule, and the board has actually, CMS has created a rule that says you must claim items on the cost report that are reimbursable. That rule doesn't even say no mistakes are allowed. That rule.
I thought there's a rule in place now on a going forward basis that requires presenting something to the fiscal intermediary, to the contractor.
It does, but it doesn't say, oh, and by the way, if you make a mistake, it's set in stone forever. It doesn't say that. It doesn't have a perfect, and if that were the rule, hospitals would have to invest even more money than they already invest in preparing their cost reports. I mean, they obviously try to be careful and avoid mistakes, but the rule here makes no sense.
So the rule that's in place now on a going forward basis that was promulgated through the Federal Register.
Right.
You think that rule can't be enforced across the board?
No, that rule is in place, but it doesn't have a no mistake rule. It says you have to claim items that you want reimbursement for. You claim an item, you can get subsequent reimbursement. So that rule does not say if you make a mistake, you won't get
So
reimbursement.
you think even if that rule were in place at the time that the facts of this case arose, it wouldn't result in your not being able to get the...
Yes, I think we would have satisfied that rule. And just quickly, let me turn to the dismissal of the resident count sub-issues. Most critically here, the government treats them kind of monolithically in its briefing, but the last three of them are all carry forward statistics from past years. Those are all inherent and indivisible from an appeal of IME. And the IME payment's different than other issues like DISH, which this court considered in Battle Creek. It's all in the present year. All the statistics come from the present year. IME, it's all three statistics from past years: base year resident count, prior year resident count, and penultimate year resident count. All of those are statistics that you don't appeal in a current case, but fortunately the secretary has the good sense to direct her contractors that they must automatically update those in an open appeal. So here, when the University of Chicago Medical Center had appeals stretching from its base year 1996 to 2007, separate board appeal, each challenging its IME payment, the board held the cases in abeyance for 10 years, waited until the base year issue was determined, which was determined by the Seventh Circuit, In 2010, that research time counts, which means the base year went up by almost 50 residents, and every year's resident count went up proportionately, and each prior year's residence count impacted the successive year. So when the hospital filed its position paper, it just explained, oh, and by the way, you will need to update the prior year statistics. The contractor, out of the blue, called these sub-issues, and the board agreed. It's unprecedented. These aren't issues that the hospital was even permitted to appeal in its board case. The board rules specifically prohibit you from appealing. It's kind of like claim splitting in court. You can't sue on challenging one transaction in one case, file a later case that says, oh, by the way, I'm also challenging that same transaction in the later case.
But can't you say, we have an appeal pending on this, this would have to be adjusted accordingly, to flag it for the, the Board on Appeal? The way that it's described in the record in this case and by the district court is that it just wasn't, there was a specific mention about the training time.
Research and training.
And the research time, but not about the rounds or whatever and the vacation time. And so that there's an inconsistency in terms of how specific. And is your point that all of those things were subject to the prior litigation, or only the ones that the intermediary omitted?
Oh, so two of them were the ones you just identified, the vacation and the additional rotations. Those were new time to be added to the present year. Those are different than the carry forward issues. The carry forward issues are ones that are not things that could be litigated, and they couldn't be raised as separate issues in the appeal in the first place. So it wouldn't make any sense to say, oh, and by the way, you have to follow the law later to update these statistics. When the hospital filed this appeal in the, I don't know, say 2005, those prior statistics weren't in dispute. Those were being disputed in each case.
Right.
But they were not improper. The contractor had applied the correct prior year statistics to determine the IME payment. The problem was those statistics later got updated through the court litigation.
Mr. Collins, before you sit down, what is an IPPS?
That's the Inpatient Prospective Payment System.
And what is an ACA?
That's the Affordable Care Act.
And what is an NPR?
That is a Notice of Program Reimbursement.
And what is a CRC?
That's the Critical Research Center.
And what is a DSH?
That is Disproportionate Share
They're
Hospital.
all abbreviations. We have a rule here, and none of them are in your glossary. So your brief is in violation. You were talking about violating rules. Your brief is in violation of a court rule.
Well, I'm sincerely sorry for that, Your Honor. I thought we had covered all our acronyms in our glossary.
Well, you obviously didn't, because each one of these abbreviations is in your brief, and they're not in the glossary.
Well, that's a big oversight on our part, so
And annoying, too.
I
Because
understand.
in order for us to understand a sentence that uses an abbreviation, we have to memorize what that abbreviation means. And in reading all the briefs for today and for the other days, it's almost impossible to do that. So we have a rule, and the rule is the glossary. At least we can look at that quickly without having to go back 40 pages to see where you finally define or first defined it.
You're absolutely right, Your Honor, and I take that under serious advisement. The last thing I'll just mention on the vacation time, that was Congress made that lawful to be included in the IME payment in the Affordable Care Act in 2010. So that wasn't something that could have been raised back when the appeal was filed originally.
It could not have been raised when the appeal was filed.
Correct.
And and it wasn't raised on, well, never mind.
We'll give you a little time for rebuttal.
Thank you so
Thank
much.
you, Mr. Collins. Mr. Lewis.
Thank you, Your Honor. May it please the court, Ben Lewis for the government. The Medicare Act gives the board the authority to establish procedures to carry out its responsibilities, and the board properly enforced its procedural rules here. In addition, the board also properly declined to hear a claim in circumstances where the provider itself was responsible for providing incorrect information on its cost report. It's important to the board that providers properly develop their claims, and the provider did not do so here, so the board decision should be affirmed. Briefly on the resident count issue, on the carry forward items that the other side discusses, those are laid out on pages 7 and 8 of the appendix to our brief. And they're just additional statutory factors that bear on the resident count for the current fiscal year. So the first, for example, on page A7, that's the 1996 full-time equivalent residence cap that they discuss. And it says that full-time equivalent interns and residents, that the total number shall be capped with respect to the hospital's most recent cost reporting period ending on or before December 31st, 1996. The next two provisions deal with this kind of rolling average that they discuss, where the 2002 resident count depends in part on 2001 and 2000. The relevant provisions also discuss the resident to bed ratio that depends on the prior year. All of these things are just additional statutory factors that bear on the current resident count year, and they're not different in kind in any way from the research time or the training time or the vacation time or the clinical rotation time that may bear on the fiscal count for a current year. There's no reason why the other side couldn't have done
Others
exactly.
they could have raised. I mean, where this
Yes.
is going is that their information was there with which this issue could have been.
Yes, the request for a hearing adequately presented the research and training time because it identified the resident count and then gave a reason why that count was an error. One sentence explanation, because the contractor excluded the research time that bears on the count, they could have included the same type of one sentence explanation that has a because clause that says that we understand the resident count in 2002 to be an error because the cap for fiscal year 1996 was inadequately calculated. And they had all the knowledge they needed at that time to present that claim. The other side is very forthcoming in their brief that it was only after consulting with a consultant about additional information that they might have raised that they decided to make these additional attempts at presenting claims of error.
What about the vacation time issue? They make a compelling case that the Congress retroactively allowed it to be included in the IME. And so and that happened after the administrative process.
My understanding of the record here is that there's no reason why they couldn't have presented a claim that it's true that Congress conclusively said that the vacation count would have counted towards them. But if they thought, and I'm sure that hospitals were pressing this argument at the time, that residents that vacation count should count to the residents count. If they wanted to press that claim before the board, then it was appropriate for them to do so through the procedural
A little
rules.
hard. I mean, something that's not supported by current law and that your trade association is advocating for in Congress. And, as you know, lawyers make credibility determination all the time. Am I going to make a weak argument that I know is a loser? That's the best you can do?
Well, that's how they would get the law changed to the courts, is through judicial review of the board decision. But to be frank, my understanding, I think, of this retroactivity point is and what the record was at that time with respect to the vacation time is a little murky. So I don't want to get ahead of myself on exactly the status of how the agency considered vacation time. And to the extent that that is a crucial argument that bears in the court's analysis, we'd be happy to submit a supplemental brief on that specific question.
I mean, it's sort of like a party preserving something to take it on bank, even though it's foreclosed by circuit president.
Exactly. There's no reason why they couldn't have included one sentence in their request for a hearing. And these these rules are important to the board. They allow the board to narrow the disputes before the parties and for the parties to resolve issues before it gets to the board. And the board benefits greatly from having the most developed version of the argument before the board at that time. Just briefly on the argument that they couldn't have raised these issues before the board because the board's rules prevent duplicative litigation. That only applies to same issues for same fiscal years. It's commonplace for a provider to say in one litigation that it's challenging the research time as to fiscal year 2001, and then to say for fiscal year 2002 to bring the same type of claim that research time was improperly excluded by the contractor. There's nothing in the board's rule that would have prevented the other side from presenting these types of additional claims with respect to the residence count, so long as they were properly presented in the rules. And just to be clear, the rules are quite clear here that the regulations in both the rules require not only the provider to identify the aspects of the determination with which the provider is dissatisfied, but explain why the provider believes the determination is incorrect in such particulars. And even setting aside their brief about why they have properly identified an issue, there's just nothing in any of their claims that would have put the board on notice that the reason why they thought the resident count was an error was because of these additional claims that they attempted to bring. Turning to the bed count issue, I think it would be useful to start by just clarifying the record on whether or not the contractor would have been on notice of that the provider had made a mistake. So I think there's a little bit of confusion here. They rely on worksheet A, they call it, to say that the contractor would have known that there was an irreconcilable dispute between the bed count that they provided to the contractor and then what they had excluded as non-reimbursable in worksheet 8. Worksheet 8 does not have a line item that says that there are 8 beds in the clinical research center that are not reimbursable. It's a list of different cost centers in the hospital, and there is a leftover bucket of non-reimbursable cost. It's not broken out into the level of granularity that would say that here are these beds that we think are non-reimbursable. And to be frank, it's not even broken out in terms of the non-reimbursable cost centers. It doesn't say that the clinical research center itself is non-reimbursable. There's just a leftover bucket of non-reimbursable costs that the provider is not claiming. So there's nothing from worksheet 8 that would have put the contractor on notice that there was a problem with the bed count. And then with respect to what they did submit for the bed count, this is on pages 250 to 260 of JA. It's in a couple of places in the JA, but the first 2 pages of that section are what the contractor did on their worksheet, and then the rest of it is what the provider submitted to the contractor. And if you look at it, there's nothing, again, on that sheet itself that would have indicated that any part of the bed count was non-reimbursable. And so from the contractor's perspective, they have a count from the provider, and even assuming that there were a line item on worksheet A that said that there are 8 non-reimbursable beds, they don't know, having received the count from the provider, whether those non-reimbursable beds have already been taken out or whether they're meant to be taken out by the contractor afterwards. There's nothing from the contractor's perspective that would put them on notice that there was some negligent information that they had received. And so I just think the other side is significantly overstating the ability for the contractor here to identify that the provider had made a mistake.
So even if it was a situation in which, I'm not going to go through all the details to construct the exact typo, but if it was a situation in which there's not a line item that puts the contractor immediately on notice, but a particularly perceptive contractor could look at various things in various places and think, wait a second, it's possible there's a discrepancy here. Maybe I should figure that out and pose some questions, which I assume that can happen. And
Yeah, even on those circumstances, we think the board's
you would still
rules are-
say that, no, that's not enough because per the board's decisional precedent in its adjudications, something has to be flagged to the contractor with enough specificity that the contractor is then going to gauge on it. So then the board will have the benefit of the contractor's analysis.
Yes,
That's
the
that's
board
your bottom line.
was perfectly reasonable to say, even in a circumstance where the contractor would have been on notice, that the fact that it's the provider that had been negligent in providing its information to the contractor is reason enough to not to hear the appeal. And I think the placing of the burden on the provider rather than the contractor makes perfect sense in these scenarios. That it is the provider who has the best cost information and is making a reimbursement request for 1 year. The contractor is dealing with requests from many different hospitals for many different years. And from the contractor's perspective, its focus is not limited to the resident count or the bed count issue. It's dealing with all the full range of reimbursement requests that a hospital of this size is making.
If I could just understand your position on how that intuition gets actualized under the statute. So suppose I know that there's an argument that there's a dissatisfied threshold and that this satisfied threshold can't be met where the provider itself has the wrong information in what it submits. Suppose I'm not satisfied, that I'm not persuaded by that.
Understood.
Okay, just assume that. I know you'll resist it, but just assume it for present purposes. Then there's the fallback position, which is that, and that's what the district court focused on, which is, look, still, this particular discrepancy wasn't flagged for the contractor. And in that circumstance, what? Is it that actually there's not jurisdiction? Is it that actually there's jurisdiction for the board to consider if it wants to, but it doesn't have to? It can have a processing rule that it puts in place via adjudication that says you got to flag things for the contractor. If you don't, we don't have to take them up. We might, we could, but we don't have to. And in the main, we're not going to. Is that where this is? That it's not jurisdiction? It's not that there's a lack of jurisdiction, or even, and sometimes it's referred to as a refusal to exercise jurisdiction. To the extent that that's the same thing as saying we have a procedural default rule that you have to bring it before the contractor, and if you don't, then we have the discretion just not to engage on it, then sure. But what exactly is your understanding of the fallback position?
So assuming that the provider has demonstrated that they're satisfied and that the jurisdiction of the board is met, jurisdiction in kind of colloquial sense, not in the judicial sense, that the statute authorizes the board to have discretion and to exercise that discretion of whether or not it wants to hear an appeal. That comes from section 1395-00D, which says that the board shall have the power to affirm, modify, or reverse a final determination under certain circumstances. And as we explained in our brief through and the case law we cite and as well as the legislative history, that is a discretionary power for the board to exercise or decide whether or not to hear a claim by a provider. And that understanding that it's discretionary is also supported by surrounding language that says that it can accept such other evidence as may be obtained or received by the board. That also supports that it's a discretionary power. So they have this discretion. The other side's statutory argument that essentially the abstention of the board is contrary to the statute, I think just fails in light of the plain language of the statute. And then their secondary argument that
So why are you relying on D for that and not E? Board shall have full power and authority to make rules and establish procedures.
in this context, the board decision, what it described was its practice. It had adjudicative.
You're saying E just has to do with actually like adopting rules.
Right. The board here, it didn't promulgate a rule, and it later did promulgate some rules that bear on this question. But at this time, through case-by-case adjudication, it said, we have a practice that we're not going to hear these kinds of disputes where the full request was not presented to the contractor. And there's no reason to depart from that practice under these circumstances because we understand the claim of the provider to be based solely on information that it itself provided to the contractor. It can't then go around afterwards and say, actually, we think that information was incorrect. It's a result of their negligence.
Some sort of rule, even if it's a procedural rule, I don't read 1395 HHC1's requirement of Federal Register publication as limited to substantive standards, which I take it to be your argument.
So I think our top line argument on the notice and comment question is that it's just not a rule or regulation or the type of standard that those provisions are contemplating. If you read the board decision itself, it says that we have a practice under these circumstances to not to abstain, and we're not going to depart from that practice. It's the same type of practice that I think a typical adjudicative body has to not hear a claim when it's not properly presented to the.
But I thought the question is not about notice and comment, but it's about publication of the Federal Register.
Oh, sorry, I apologize. Yes. So
and then there's a Federal Register.
I think the same argument applies to the Federal Register argument, but they say that, I think briefly in their reply brief, that they are prejudiced by the failure to publish, and that just can't be true. There were prior board decisions that we have cited in our brief that were available to them at the time that had already announced that practice.
What's the key one, or where should I look?
I believe Affinity or.
Just so I'm understanding, what are you looking for?
Board decisions that would have put them on notice, even in the absence of a federal.
Yeah, Affinity Medical Center versus Blue Cross Blue Shield Association, National Government Services, which was precisely the scenario that, the same scenario that we have here where the.
Where is that cited in your brief? I'm not seeing.
I'm sorry, page 43 of the brief.
In the table of contents.
Yes, apologies for that. 43 to 44 are the discussions of the prior board adjudications. And so Affinity explained that where the hospital included a number of beds on its cost report and the intermediary did not adjust, the board declined to hear the appeal for the exact same reasons. And so at the very least, even if they would try to distinguish that case on its facts, the analysis looks very, very similar to what the analysis was here. The board announced a practice that it wasn't going to hear these issues under similar circumstances. Do you
read the Federal Register provision just not to apply to standards like this that are announced via adjudication?
I do read the Federal Register. It refers to the promulgation of, it says a list of all manual instructions, interpretative rules, statements, policy, and guidelines of general applicability, which are promulgated to carry out this chapter. There was no promulgation of the sense that that kind of provision is talking about.
So your view is that the board just has inherent authority to adopt rules like this, that I'll call them rules. I get that that's a term of art, but to adopt standards like this that organize its consideration of issues so that it can do things in an informed way. And one of those standards is that, look, you got to present something to the contractor.
Yeah, I wouldn't even call it a standard here. I think this is really a site-specific analysis for case-specific reasons based on the provider's negligence, and so it doesn't even fall.
But one of your points is that the board consistently does this, and so in that way, it's not.
It has done it before through prior cases, but it's not as if that's binding precedent on the subsequent board, and that the board couldn't depart from a practice for case-specific reasons.
Yeah.
And then, yes, I'd say our second line argument is.
And so for that part of it,
Yeah.
the board has the inherent discretion to do these kinds of things in adjudicating a particular case. D of the statute just kind of encapsulates the existence of that kind of discretion, but the board just has that kind of discretion as an inherent matter.
Yes, I think even if there was no statute D provision, that the board, by virtue of being an adjudicative body, can adopt the kind of practice that, yes, that as
And
judges.
that's not subject to the Federal Register requirement, because that one only, in your view, applies to the promulgation of rules by the agency, not the decisions in adjudications by the board.
Correct. In order to analyze and resolve disputes, the board has to decide whether an argument was adequately developed and whether it was adequately presented. And that often involves the kinds of judgments that are made here.
Yeah, kind of like in your first brief, you got to flag an issue, otherwise.
Exactly. And if all of those decisions were published in the Federal Register, it would be even longer than it already is. If there are no further questions.
Thank you.
we urge the court.
Yep. Thank you. Mr. Collins will give you 2 minutes for a rebuttal.
Thank you again, Your Honors. Just first, the carry forward question that the Secretary's never denied that the contractor is obligated to automatically update those factors. So he forgot to mention that. So
Obligated, even if it's not ever identified to them as something
right.
that's
I mean,
outstanding or that you're asking for.
the Secretary's statement in the Federal Register is very clear. It says the contractor shall update those numbers and apply them to subsequent open cost reporting years. And that's cited on page 34 of our brief Federal Register site.
Is
And-
open cost reporting years, does that refer to matters that have not already been submitted to the fiscal intermediary and or appeals to the board?
It means if a matter has been, if it's open because it's not due yet, or if it's been submitted through a board appeal, that's considered open. And the appeal of the resident count, you can't get a correct resident count in the present year without the past year statistics. So it has to encompass those past issues. The board's rules in no way, shape, or form told providers that they needed to delineate every single aspect, every variable, if they wanted to appeal the resident count. Never. And more recently, they've gotten more nuanced, but not at the time we filed our appeal. So they can't spring this on us when it's way too late. The vacation time and the additional rotations, I mean, those are not matters encompassed, but those are necessary to get the IME payments right. And the board is sitting here with an appeal where it's correcting numerous issues. That is the poster child situation where the board should exercise subsection D authority. That's an expansion of its authority. The board reads that as off limits. We will never use that for any provider in any situation. They read that out of the statute.
But to the extent they also rely on discretion, no?
Right. But, and all of the board's precedent dealing with what providers have submitted on the cost report involves situations or it always involves unclaimed costs. And the one precedent that was in existence when the hospitals filed their appeal and when they filed their cost report was Mayo. The Mayo case permitted a hospital to correct through a board appeal an error that it made. In 2010, the Affinity case that they referred to, that my friend on the other side referred to, that was 2010. The board changed its position. That was long after we had filed our appeal. So there was nothing hospitals could not know that this was something that they needed to do. Likewise, just when the contractor asserted the argument that these were that you could not correct, you can't appeal an item that needs to be corrected. Taking the past decisions of Little Company Mary, all those decisions one step farther, that was after the hospital could even ask the contractor for reopening. They filed that issue out in 2006 when they were still within a 3-year reopening window. The contractor waited until 2013 to spring that jurisdictional defense on the hospitals.
Let me make sure my colleagues don't have.
May I just mention one important thing relating to the bed count?
Okay.
Council represented that it was completely hidden somehow. It was on worksheet A. But first of all, the board's decision references, it never addresses the fact that there's this conflict on the face of the cost report. We cited that.
Okay.
The administrative record actually shows the work papers that were filed with the cost report. It is delineated. There's a line.
Can you just point us to the page and then
Yeah.
we'll do the work?
They're in the administrative record. They're not in the joint appendix. So in the administrative record, and we could submit this as supplement if the court would like, they're page 312 and 309. Those beds are specifically identified and the cost center is specifically identified as non-reimbursable. It's not just mixed in with everything else.
Okay, good to know. Thank you, counsel. Thank
Thank you,
you
Your Honor.
to both counsel. We'll take this case under submission.
Case number 25-1599 et al. Jane Doe et al. Versus Pamela Bondi in her official capacity as Attorney General of the United States, and William K. Marshall III in his official capacity as Director of the Federal Bureau of Prisons, appellants. Mr. Hayes for the appellants, Ms. Levi for the appellees.
Good morning, counsel. Mr. Hayes, please proceed when you're ready.
Good morning, Your Honors. May it please the court, Benjamin Hayes for the appellants. If I could, I'd like to reserve 3 minutes for rebuttal. The President issued Executive Order 14168 with the goal of protecting the dignity, well-being, and safety of women, including by ensuring that males do not invade the intimate single-sex spaces of women. The Constitution indisputably allows the Bureau of Prisons to house males with males and female with females, and nothing in the Eighth Amendment requires the government to treat these plaintiffs any differently than the 1,400 other plus trans-identifying men already housed in male facilities. That is especially true here, given the extensive efforts of the Bureau that the Bureau has taken applying its expertise in this area to minimize the risk of harm to plaintiffs in the facilities that have been designated for them. The Constitution requires nothing more. So if I could, I'd like to start with, there are two threshold PLRA questions and then move to the merits. So of those two, there is the judicial review bar, and then there's the exhaustion bar. The judicial review bar says, notwithstanding any other provision of law, a designation of a place of imprisonment under this subsection is not reviewable by any court. From our perspective, that is categorical, it is all-encompassing, and it does not admit of any exceptions, including an exception for as-applied constitutional claims, which is what the district court held. And there are a number of Court of Appeals cases, the Willis case from the 10th Circuit, for example, which agree with us on that. If you were to disagree with us on the judicial review bar.
Can I just ask you a question about that one first before you go to exhaustion? On that one, the bar speaks in terms of the designation of a place of imprisonment under this section. And what I'm wondering is, that means a designation of a place of imprisonment under the section that gives the BOP the obligation to designate a place. And so if the challenge is to something that comes before the BOP makes a designation, because as I understand this, that it wasn't the BOP that came up with this rule. It was the executive order. The president came up with the rule by executive order. And of course, that decision is implemented through the BOP. But does the bar apply in a circumstance in which the challenge isn't actually to the designation under this section, in that it's a decision made by the BOP under this section? It's to a decision that the BOP has to implement. But it comes before the BOP exercises this discretion.
I understand what you're saying. I mean, so it is, just as an initial matter, it's a little unclear with respect to exactly how plaintiffs are approaching this, because in the context of this issue, they want to say their challenge is against the broad policy. In the context of the Eighth Amendment claim, they would say, no, we're perfectly fine with that. Generally, it's just specific to us. So it's a little hard to get a
Right,
hold of.
let's assume for these purposes, it's to the policy.
Focus on this. Well, I think, first of all, there are designations right now, right? Those have been made. And so I do think it's somewhat artificial to say, or that the challenge would only be to the policy, even though we have right now
So
designations in place.
In one situation, you may be totally right about what the state of affairs now, but at least in one situation in the appendix, and I can try to find it, but there was a discussion of somebody as to whom no designation has been made, could have been made because it wasn't even clear to which facility they would be assigned.
So I think for maybe two, that might be true. And I think maybe two for whom there were designations put on hold. There's another one, I believe, who was in a halfway house, and so is not going to be moved regardless.
So just for purposes of understanding the
focusing on
concept
that.
with those people.
So I think it counts as a designation for this reason, because a challenge to in this case, it obviously would apply to a designation to a facility. We understand, we agree with that. But I think that the key here is that a challenge to the policy, the EO, and invalidating the policy has the effect, is no different than a challenge to the designations. It would mean that they cannot go into effect. So that's different than the context in the McNary case, for example, that they cite. That case was talking about a background policy which might influence a determination. This didn't have to do with the BOP, but a determination as to an individual's eligibility for a program. And invalidating that policy didn't determine
the underlying individual designation didn't affect that at all. It could go one way or the other. Here, where they're challenging the policy, and if they prevail on that, that means these designations are invalid. So I don't think there's really the daylight that might otherwise exist in the context where there's a challenge to a policy, but there's individual designations. I don't think that's at play here. And so
Wait,
that's,
I'm not following that. You said McNary doesn't involve individual decisions?
no, what I'm saying is McNary involved I think it was a pattern or practice challenge to a way that the INS was managing a particular program. There were individual eligibility decisions made, but the point there was that a challenge to the background policy didn't necessarily change the determination for the individual. The INS could have reached the exact same determination. It just meant you need to look at the individual and see if they're eligible without this background unlawful thing happening. So in other words,
Well,
it
the
didn't.
background, I'm not sure that I'm following how that helps you. The background unlawful, what the court said in McNary was with the special agricultural workers, they could not get review of a determination respecting an application. And the Supreme Court held that that precluded review of individual decisions because of the language of it, but not a challenge to, quote, a group of decisions or a practice or procedure employed in making decisions, which to my mind sounds just like what the plaintiffs here are challenging. And your distinction of that is?
So the reason I think it's different is because here, if they succeed on the challenge to the background policy, the EO, that necessarily invalidates the underlying designations. That would have to follow from it. That's not true in McNary, right?
Well, it would invalidate the individual determinations to the extent that they rested on it, and then they could be remade, presumably?
This the same in McNary, the same one, yes, the same ones could be. Here, not true.
But that's
Okay,
neither here nor there with respect to the applicability of the jurisdiction.
Okay, well, that was why I thought McNary was different. But if you disagree, we still, and think the judicial review bar doesn't apply to here, we still have the exhaustion bar that is written in the statute. This isn't, it's written in the statute. The Supreme Court has said that it is mandatory and doesn't have any, extra textual exceptions. And that review bar, the Supreme Court has said, applies so long as there are administrative remedies that are available. And the court in Booth explained what availability means.
So can I just ask you on this one?
Yeah.
This is where I'm coming to on this one. You tell me what's wrong with thinking about it this way. It seems to me that whether the exhaustion bar has the dead end possibility, which means that then you don't have to exhaust if it's a dead end.
Right.
Everybody agrees on that, right?
Right.
So it turns entirely on the way the substantive claim is framed. And so if the substantive claim is framed to say that there's nothing that could be done in a male facility that would alleviate the constitutional injury, there's just nothing, then it seems to me that exhaustion is by definition a dead end. Now that has consequences for the substantive claim, because then as you raised with respect to the other bar too, the way you frame the substantive claim matters for the merits.
Right.
But for purposes of exhaustion, if the substantive claim is, look, there's just nothing that can be done at a male facility to alleviate what I assert is my constitutional injury, then at that point, it does seem like exhaustion by definition is a dead end, even though you could say, well, there's things that can be done at a male facility that would, in our view, alleviate the injury. But if the claimant says, no, that you don't understand, my claim is that by definition, just being in a male facility is itself a constitutional injury, then isn't exhaustion a dead end?
I don't think so, Your Honor. And I don't think exhaustion, I don't think exhaustion requires that the administrative process be able to fully ameliorate the constitutional violation. That's what I take from Booth saying some relief. Booth says it doesn't matter if you can't get the exact relief. So the relief the plaintiffs here seek is halting these transfers. And that's the rationale of the district court. And the BOP certainly doesn't have discretion to do that.
I think the difference is that I understand what you're saying about Booth. I think the difference is it's true that that's the relief they seek, but it's also the claim that they're making, which is that's what's different from Booth, is that it doesn't alleviate. It's not just that it's not the relief we seek, it's that the claim we're making is that being in a male facility, period, is a constitutional violation. Now, you may respond and say, well, okay, well, that makes your constitutional claim on the merits tougher. And that may well be right, but in terms for exhaustion purposes, it just seems to me it's like the case that we had about DNA, If the claim in DNA were, in that case involving DNA, were that I'm worried about what you might do with the DNA sample, then there could have been some exhaustion because it could have been, well, let's figure out what we're going to do with it. But the claim was, you don't understand, it's a violation of my religion rights to take the DNA sample, period. At that point, there's just nothing that could be done with exhaustion. And it seems like that here with me.
So I agree that that's the reason. I understand that was the case in that case. Here's why I think it's different, because regardless of how they're framing their claim, they're still bringing an Eighth Amendment claim, right?
Uh-huh.
And that has elements. That is a substantial risk of serious harm, which is objectively intolerable. So the question is, regardless of what their theory is about it and what they think will satisfy it or not, that's the claim. And so it's just a question of how much risk. And so that's why I think it is different, because there is something they can get from the administrative process, which will reduce that risk. It may not be everything they want. Fine. Some relief doesn't require
Not
that.
only that, but is it correct that each facility that houses, whether men or women, has to go through audits now on the prison rape statute?
There are extensive procedures that they have to go through, both when individuals are.
And there are audit reports that come out with respect to the compliance of the particular prison or facility that has all kinds of, I've read some of these, I mean, all kinds of details about what is being done or what should be done and so on and so forth. And it would seem to me that the question of harm by being transferred may well depend on a number of factors, not the least of which is what the facility is that they're getting transferred to, what it's done with respect to that prison, rape statute.
So I agree with that. It depends on.
We don't know. I can't find, maybe it's in the record, but do we know from this record what prison they were going to go to?
Yes.
We do.
Yes.
Do we know what crime they were imprisoned for?
I believe as to one, yes, as to the others, no.
One of them, well, one said it was not a crime of violence.
Right. I don't think the
know what
record
the crime
reveals
was.
the crimes, but the record does show which male facilities each of the, with the exception of those who have been put on hold, are destined for. So I think I've said what I was going to that.
I want to, before you run out of time, I have a couple of questions I want to ask. And the first is that I wonder whether yanking somebody out of the women's prison immediately is in compliance with the executive order. And here's why. The way I read it, if I can find it, is you got section 4. It says the Attorney General and Secretary shall ensure that males are not detained in women's prisons, et cetera, et cetera. But then in sub B of section 8, it says this order shall be implemented consistent with applicable law. The regulations are applicable law, and particularly 115.42 says that before you transfer anybody, you've got to go through a whole series of steps with respect to ensuring their safety. And from the record we see here, I don't see those steps have been made at all. It's just, come with me, we're transferring you. So how is the transfer consistent with applicable law? If it's not, then it's not consistent with the executive order.
Well, so I believe there were several declarations submitted by Mr. Stover in both the Jones and the Doe litigation, which identify that each one of these individuals was given a holistic assessment when it came to which facility to move them and which one to move them to. So there was a holistic assessment made as to each of them. Now, I don't know that.
Yeah, I'll take a look at that. But before you sit down, let me tell you, and put this on the table. I don't think we have jurisdiction in this case. And the reason is because the way the statute's worded, the preliminary injunction has to expire automatically within 90 days. Unless it's converted to a final injunction. And so there's an opinion by Judge Choflat. I don't know if you're familiar with it, the Georgia advocacy opinion, which goes through the statutory interpretation. It's a case that's identical to this case. And he holds for the 11th Circuit that they didn't have jurisdiction. Another way of framing it is that whether there's been compliance with a preliminary injunction or whether a preliminary injunction should be set aside is moot. The case is not moot because you can still go forward with respect to the merits and with a view to a final injunction. But that's going to require, it seems to me, evidentiary hearings that clear up a lot of the questions that you've been answering about where the harm is and what prison it is and what offense they committed and so on and so forth. So as I understand it, and I'll let you respond, I understand it what Judge Lamberth has done is right before the 90 days expire, he issued another injunction, another 90 days, and another 90 days. I don't think you can do that under this statute. Maybe if the situation had changed, that would warrant a new injunction, but he made a specific finding that nothing had changed. And so he just reissued it. And that seems to me in total defiance of the statute.
So as I understand it, that is what is being done in the district court in terms of 90 days, and then they are being renewed. And I do agree that it is simply just a renewal of the same thing, that as if nothing has changed. I don't really I haven't read that decision, so I really can't comment on it.
Well, let me give you the citation if I can find it. Oh, here it is. It's 4 Fed 4th 1200. And it's a very extensive analysis of the statute that we're dealing with here. Now, I should add that what happened after Judge Choflat ruled is that the parties got together, it was a transfer, and settled the case. And so he vacated that opinion. I don't know if you can vacate opinions, you can vacate judgments, but he did. But anyway.
Okay.
And you also, the government hasn't taken the position before, I understand.
I don't believe that we have in the district court taken that position.
I mean, if that's a jurisdictional issue, we'll have to look
That
into
would matter.
it.
Correct.
Can I ask you
Yes.
back on exhaustion? So I sort of see this in two different ways. Like the way that Ross talks about it is that in looking at both, you know, that you're only required to exhaust if the grievance procedure is capable of use to obtain some relief for the action complained of. And you and Chief Judge Srinivasan were talking about this just before that. And here, the action that plaintiffs complain of is BOP's new approach of categorical transfers of all transgender women without regard to their individual characteristics, transferring them all to male facilities. And if that's what the plaintiffs are complaining of, then there is nothing that BOP can do. And I think BOP concedes this in its briefing. We can't decline to transfer these transgender women who are now in women's facilities. We have to. And so if what you're complaining of as a matter of the Eighth Amendment is that decision, we're going to transfer them all, whatever their individual vulnerabilities may be. But then as I read your brief, you say, well, the action complained of is a substantial risk of serious harm from that action, which is, you know, part of how they have to argue the Eighth Amendment violation. But even accepting that framing, then the Bureau says, well, there is some relief that can be given. And I'm not sure that what you point to, that I understand that to be some relief that would be a result of going through exhaustion. For example, it's mainly citing to the Stover, one of the Stover declarations, and it points to things like, general practices of the Bureau that aren't related to the grievance procedure, that aren't triggered by the grievance procedure, that aren't, tailored to the individual as a result of the grievance procedure. Just like BOP has commendably programs for training staff, programs for tracking, disciplining, and potentially even prosecuting aggressors against other prisoners. That's there whether somebody engages a grievance procedure or not. And then the one thing that I see that could be more specific is putting the victim in protective custody in the special housing unit. And there, another one of the Stover declarations talks about how that is not something that can be used for any extended period of time. It is a very, very restrictive kind of confinement. And so I just, there may be things, and I understand, I appreciate your reading of Booth as like, it doesn't have to be the full, brass ring that the plaintiff wants, but if there are things that can come out of it, and, and Booth is very, open-ended and says there's value in process, there's value in exploring things, but I don't see the Bureau as pointing to a single thing
Well,
that is actually responsive that could come out of it.
I mean, I think this is, I do take your point about just reference to the PREA regulations. Yes, you have to do that screening, but that's not specific to, but here's what is. The Bureau has, and each facility has, exceptional discretion when it comes to managing the populations in the facilities. So for example, these are low security facilities, and I think there's different layouts as to how they're set up, but there are units. And if there's a particular inmate who is a threat, for example, to another one, that can be noticed by the officers in the facility. It can be told to them by the potential victim. And if it's a problem, they can move that person to a different unit. If they're on the same work unit, for example, and there's trouble there, they can move them away. I believe some of the declarations discussed showering. Now, in the regs, there is already in place a requirement that they have separate showers. So that's already there. But talking about locks on doors or something like that, they have discretion to take those kinds of steps, which absolutely address risk of harm. And I think maybe it doesn't bring it down to 0, but I think that if the risk of harm is 10, pre-use of the administrative grievance process, and they bring it down to 7, that's still some relief that is being given to the plaintiff. Maybe not all they want, but again, Booth says that's not what's required.
Maybe those, I don't see those things fully spelled out as a result of exhaustion. I read pretty carefully the pages of the Stover Declaration of the record that were pointed to, but if BOP is not unable, there is a question in the record whether it's consistently unwilling to do those things. For example, we do have evidence of 2 of the plaintiffs, I think it was Mary Doe and Jane Doe, who were assaulted in male BOP facilities. The BOP was made aware of that, and then they were assaulted again. So there, to the extent that there are these measures, the plaintiffs have put evidence in the record that they are not effectively being used. We don't have very much information about these plaintiffs being in male facilities, but to the extent that we do, it's not showing that BOP's awareness triggers, would render the exhaustion something that is worth doing. And then there's a whole other question about the time that it takes.
Sure.
If you're one of the what is it, like 1% of the transgender women that are in BOP custody now, that has, on an individualized basis under the PREA regulation, not been placed in a male facility. These are presumably, and I understand your briefing saying it wasn't only based on vulnerability, that they weren't placed in male prisons, but surely that is a factor. And these people are not allowed to sue unless they go through an exhaustion process that has a standard duration of 90 days.
Well, so if I could address that. So it is true that some of the plaintiffs in their declarations discuss assaults and such in male facilities. Now, what we have here, a lot of it's unclear as to what male facilities, and it matters because if you're talking medium security versus high security versus low security, the risk differential is quite different there. The two that you might have been referring to, I remember them being Rachel and Ellen, were temporarily moved from their female facilities to the male facilities and then back as a consequence of the injunction. And they did not, I don't remember exactly how many days they were there. They were not sexually assaulted there. Now there was innuendo.
There was harassment. I
There
was
was
talking
harassment, but-
about two other women who were assaulted in facilities and then again actually assaulted. I understand that
Right,
that
right.
Rachel and Ellen, but again, I mean, Ellen Doe said, you know, there's no locks on my door. I can't sleep.
Well,
And
Well, and to your point about the length of the review process, and this is where the Fletcher case, the plaintiff's site is actually quite helpful because
the witch is?
Fletcher, it's from the Seventh Circuit.
Yeah,
And,
the Posner
and so,
decision.
yeah, Judge Posner's decision. And, you know, Judge Posner goes through an analysis saying, well, it might be that there is a risk that is so imminent, like right on the doorstep, that no administrative process is swift enough to address, essentially at his point. But he said that the plaintiff in that case had to exhaust. Why? Because the Illinois Department of Corrections had an emergency grievance proceeding in it that would address claims more swiftly. The plaintiff waited 2 days, filed suit, and he says that's not enough. Here we do have in the regulations an emergency procedure grievance process that can be submitted to the warden and requires a response within 3 calendar days. So there are, and that's for situations where there is like an imminent risk to physical bodily harm. I'm paraphrasing the language. So my point is there are accommodations or procedures that are not just in 90 days, which I agree, that doesn't address something that's very near term, but there are administrative procedures available to account for what Your Honor just mentioned in terms of near-term issues. I want to cut you off.
I just wonder if there's anything else in the record other than the portion of the Stover Declaration that's cited in your brief. I think it's the your brief at 32 cites JA 308 to 310, which is the first Stover Declaration. It doesn't include anything other than what I view as sort of the background BOP policies or placement in special housing unit. And I take it you don't see the placement in special housing unit as a kind of a durable solution. You're not going to have these women living in the special.
They are not going to be. It is a solution for a particularized issue. If there is something like someone said they were going to kill me now, and you could like take that quickly, but short term.
The person who's going to kill you in the special housing unit rather than the potential victim.
I actually don't. I don't know if you could at least put the victim there to keep them separate. I don't know actually whether they could do either one. I just don't have information.
I mean,
about
it's
that.
typically seen as somewhat punitive to be
Right, which is
in
why
solitary.
which is why I think the point was made subsequently that this is not a long-term solution to it
Yeah.
because it's not meant to do
Yeah,
that.
that's your supplemental submission.
If,
So I don't see individual, you know, that something can be done under both, but
so I don't right now remember like a JA site to the kinds of things I just described in terms of just the ability of the facilities to manage the prison populations and keep people separate from one another, which they can do and they do on a regular basis. And I believe, and I don't remember which plaintiff's declaration mentioned this, there was recounts an incident where that plaintiff mentioned to a guard, I don't think it was at a prior facility, someone's causing me a problem, and they were able to separate them so that person wasn't housed near that plaintiff. That is exactly the kind of thing that can be achieved through the administrative process. I know I'm way over, okay.
I have one more question before you sit down. Do you view this case as a facial constitutional challenge to an executive order?
Well, I think it partly depends on which part of the case you're talking about. So if focused on the Eighth Amendment arguments that they make, the plaintiffs make, their argument is that they are particularly unique. And so it is only unconstitutional as to them, and that they are, and as far as I can tell, they are not taking the position that it is unconstitutional for all 1,400 other trans-identifying men to be in male facilities. Now, we don't agree with the premise of their position, but just to answer your question directly, I think it is their Eighth Amendment claim, forgetting anything else, is phrased as an as-applied challenge. I know I'm way over time. I can talk about the Eighth Amendment
Well, the reason
issue.
I'm raising that is because whether it's global for everybody with, in their situation, regardless of which prison they're in, or whether it's just confined to the, how many are there, 22?
There are 19
Nice.
plaintiffs here.
19 plaintiffs in various facilities,
Yes.
or whether it's even confined to them. The reason I'm asking that question is because it doesn't seem to be specific to their particular circumstances, even if you narrow the universe to the 19. And if that's the case, it's a facial attack. And if it's a facial attack under the Supreme Court's decision in Salerno, that you have to go through each one of these individuals to determine whether it would be unconstitutional to put them in a men's prison. You can't do it globally because if there's, unless it's unconstitutional with respect to each one, then the court can't issue an injunction under the Salerno rule.
So I absolutely agree with that. And so while I will say that they frame it as applied challenge, we don't think that the features that they say make them distinct and unique from all 1,400 others stand. And they're not even features that are unique to all of them across the board.
Right.
For example, some mentioned that they've had surgeries. That's I think a quarter of them have. All of them have had hormones, but that's true of others, other trans-identifying males in male prisons right now, which means that they are not the only ones also who have.
But those strike me as,
Subject to the policy because they're not being transferred.
those strike me as merits points, and they're merits points that need to be reckoned with, but they don't, I think, convert an as-applied challenge into a facial one just because the criteria that are being articulated by the plaintiffs wouldn't apply to all 19 plaintiffs. Those are merits responses you have. And I don't know of a principle that says, because that's true, it makes it a facial challenge.
Maybe so. I was trying to get into the merits.
Well, it
I just want
is.
to make sure I understand where you are.
The Chief Judge is absolutely correct. It is a merits thing. But you have to consider the merits if you issue a preliminary injunction, because one of the criteria is likelihood of success on the merits.
Right.
And that's what I'm
Yeah,
talking.
and it definitely goes to that. I guess all I'm trying to say is that I don't know that that would convert either a meritorious or unmeritorious as-applied challenge into a facial challenge. It's one that might make it a more difficult merits
Well, I
argument to
guess,
prevail on. But
I guess my point is that the features that they try to point to say, we are unique, do not hold up, which means that they are not distinguishable from all others who are in male prisons. And then the logical consequence of their argument at that point would have to be that the Eighth Amendment requires that 1,400 other trans-identifying people be moved over to male prisons. They disclaim that. They say that's not right.
But I don't follow that because they're the only ones who are being transferred. They're challenging a transfer policy, right? They're challenging a transfer policy, transferring women who are currently housed in women's facilities. I'm sorry, transgender women who are currently housed in women's facilities to men's facilities. All those other 1,500 odd are not being transferred because they're where the executive order wants them to be. They're not plaintiffs in the case. They're not affected. They're not affected by the district court's preliminary injunction against transfer of transgender women from women's to men's facilities.
I'm not suggesting that anything that happens here will have a direct effect on the other 1,400. I'm just talking about the logic of their argument. That's all.
in other words, the other 1,400 could bring a claim that said, I should be transferred.
Based on the logic of their argument,
That's what-
yes, so one of the arguments that they make, apart from substantial risk of harm, right, based on being victimized, the district court made this point that they would, independent of any harm from individual other inmates, they would experience a substantial risk of harm just by being in a male facility because it would increase their symptoms of gender dysphoria. That would be true as to every single other trans-identifying person, male, in male facilities. The evidence they have is not unique to them. There's two declarations which are identical on this point, and it just says exactly what I just said. There's no differentiation between them and all 1,400 others who are in there. So that's the same point I'm trying to make is
Right.
the
The
logic of their
upshot of
claim.
which I think is, as I understand your argument, is the upshot of that would be then somebody who suffers from gender dysphoria but is in a male prison could bring a constitutional claim of an entitlement to be transferred to a women's prison.
Someone and all of them on that theory,
If the
yes.
theory-
It's not individualized
you
at all.
understand.
Right. It's not individualized at all. The evidence they've submitted is not individualized at all on that question, certainly.
So the district court ruled on constitutional grounds, but it seems to me that one of the really clearest violations on the merits that BOP has on its hands is, I mean, even the executive order says, as Judge Randolph noted, that this has to be carried, that the executive order has to be carried out consistent with applicable law. And it particularly identifies and calls out in section 4, in ensuring that males are not detained in women's prisons or housed in women's detention centers, including through amendment as necessary of the PREA regulation, right? Part 115.41. That regulation has not been amended, except that it's been effectively amended through BOP's series of actions here without going through notice and comment.
I mean,
Do you have a merits response to that, or is it just the jurisdiction stripping and exhaustion?
well,
Well, exhaustion doesn't do anything for that.
well, so it is also, well, there are a few things about their APA claim. The first is, this is not a basis on which the district court ruled, as Your Honor just mentioned. And that is, something that's important in most cases. Usually this court reviews and doesn't take up issues on its own. I think it's especially important here because this court held in the Shelley versus Sebelius case that we cite in our brief, that in the context of a preliminary injunction, the court should not just it's not a matter of discretion, ought not to, should not reach out to affirm a preliminary injunction on the ground that was not embraced by the district court, because granting of a preliminary injunction is a matter of discretion. So I don't think the court has the ability to do that anyway. And in addition, I think it would raise some significant issues with respect to the PLRA, because that requires the district court to make findings that the particular injunction that is being issued is tailored to the injury that is being found. An Eighth Amendment injury is not an APA injury. They're very different things. So I think it would be very difficult to even reach the APA claim at this stage. Anyway.
In terms of the Shirley versus Sebelius, as I read that case together with subsequent decisions of our court and the practice of circuits nationwide, I have to understand Shirley versus Sebelius to advert to the fact that there were exercises of discretion by the district court that mattered in the ground that was being proposed as an alternative ground. We have since then the In re Federal Bureau of Prisons execution protocol case in 2020, where our court did consider an alternative theory and affirmed a preliminary injunction because it rested on purely legal arguments. And here too, this argument about the failure to do notice and comment rulemaking to depart from the pre-regulation is a purely legal one. And so even though you're right that formally all injunctions they're equitable, it's discretionary, I have to read our binding case law to, how do we reconcile Federal Bureau of Prisons with Shirley versus Sebelius? And I think and it's quite common nationwide that circuits where there's a purely legal issue that the Court of Appeals is in just as good of a position to address as the district court, that injunctions are frequently affirmed on alternative grounds. So if we go ahead and address that if you want to.
I'm the only thing I was going to say is I don't know that I'm familiar with the latter cases that Your Honor cited. What I thought was the case in Shirley was that it was also the alternative ground was an APA ground, but I can't remember the exact specifics of it. So, but I thought it was an alternative ground, and the court did not reach it.
It's APA, but I think it depended on more fact-intensive issues. It's just a lot of different issues in the brain today, but and in terms of on the merits, assuming that it were passed on by the district court or that Shirley versus Sebelius is not an obstacle, you were saying you didn't think that the plaintiffs would get relief from it? I'm not sure
No.
what you were arguing, because
The second thing
the point about, I mean, this is the rule that says, look for whether a placement for a transgender woman, consider whether to place them in a male or a female facility. I mean, that is the rule that they want to have still be in place, the plaintiffs.
No, I didn't mean to say that. I think what I meant to say was, because we're dealing with an injunction issued under the PLRA, there are special rules that apply to issuing injunctions under the PLRA, which means the district court, has to look at the particular harm that is found and whether, the scope of the injunction and the nature of the injunction are, appropriate for that and as narrow as possible.
You're talking about the need, narrowness.
Exactly. I can't remember the exact subsection, but, and I think that analysis could very well be different if the harm, as between the harm being identified being an Eighth Amendment claim with a substantial risk of serious harm, et cetera, versus an APA claim, which is, go through notice and comment, or their other theory being that different alternatives were not considered. So I just think those are at least could be two different things, which is a reason to let the district court do it.
I see that as an abstract matter. I'm not sure I see how that would play out. For example, here, just because it's a little bit cleaner, consider the rulemaking. They're basically saying you have to abide by the PREA regulation unless and until it's been duly repealed through notice and comment. And the relief for that seems to me to be on all fours with the relief for to the extent that you think their Eighth Amendment claim is challenging the transfer of these trans women with their vulnerabilities to a male facility. If that's the action complained of there, it seems to me it's pretty overlapping.
That might be the way the district court would work it out.
But do you have, I'm just interested concretely if you can sort of fill out where you think the district court might come out differently.
I really don't know,
Got it.
honestly.
No, I appreciate
really don't know that. But in addition to what we've just been discussing, I think on the APA claims, there is also a review bar that applies to the APA claims too. And I think in this context, some of the discussions that we were having about, I see I'm way over time, so tell me, some of the discussions we were having about, a challenge to the policy versus a challenge to the designation sort of fall away. Because the policy here is the EO, and you cannot bring a challenge, APA challenge to the EO, and the plaintiffs, I think, acknowledge that. So the only other thing they could challenge is the designations. And that's what the APA review bar says you cannot challenge. So this is much cleaner, certainly at least, than the initial bar that we were talking about before. And so the first thing that you would confront if you decided to move past all the things we've just been discussing would be a judicial review bar saying these are not questions that can be adjudicated.
Which the district court didn't look at that either. Because
But the district court
it
did not.
didn't treat with the APA claim.
And because I believe in one of the district court's orders, he said, because they may well be barred. That was the reason given for, the normal course would be to address a non-constitutional argument. And so he addressed the Eighth Amendment because on the belief, and I think that's explicit in this decision. It's also explicit in some parallel litigation in the Kingdom litigation where same judge decided the APA claim and not the Eighth Amendment claim. So I think that is the reason. And
And also because maybe the 3621 bar he thought didn't apply to constitutional claims. Right, that was part of his rationale in getting to the Eighth Amendment question.
He relied on Webster versus Doe.
Right. If the honors have no further questions.
We'll give you a little bit of time for rebuttal. Thank you. Mr. Hayes. Levi.
Thank you, Your Honor. Morning, Your Honor. Your Honors, may it please the court. Jennifer Levi, I represent the plaintiff appellees in these three consolidated cases. This case is about preventing the sexual violence that will be perpetrated against these 19 transgender women currently housed in women's facilities who will be transferred to men's prisons if the court vacates the injunctions below. Plaintiffs ask this court to affirm because it's the executive order that forces the Bureau of Prisons to disregard its own safety determinations and transfer these women to the very facilities that BOP previously deemed inappropriate for them. This isn't about some abstract questions or philosophical debates. This is about the constitutional limits on prison officials' ability to ignore known and serious violence risks. These women will face the same brutal reality that any woman would face if forced to live in prison among men. They will be sexually assaulted, raped, and violently attacked. And we know this because it's already happened to many of them. All of those previously housed in men's facilities have been repeatedly sexually threatened or violently assaulted and raped, some of them repeatedly. And when 2 of these individual plaintiffs were briefly transferred, they immediately faced sexual victimization.
So can I just make sure that I understand the scope of your theory on the merits? You say in your briefing that you don't think that it's the case that every inmate, every trans woman inmate needs to be, as a constitutional matter, in a women's facility. So the theory that you have can't cover everybody because you already say that it doesn't cover them. And so I guess my question is, what is it that ties together the particular 19 plaintiffs that gives them a constitutional entitlement that wouldn't then be over-inclusive in covering everyone, but also is not under-inclusive in the sense that it actually covers all 19? And the one thing I can see that does cover these 19 and nobody else is that they were all assigned to a women's facility. That's the one thing I see. But beyond that, and then we can talk about that, but beyond that, it seems like everything that's being asserted in the briefing either covers substantially, a population substantially more than the 19, or it doesn't cover all 19.
Well, 2 things I want to say in response. One is certainly they're unique in that they have been designated as being appropriately housed in women's facilities. The other thing which is unique, which is that they're in women's facilities, and if they're transferred from women's facilities to men's facilities, they will be targeted because of being women that BOP has recognized as women appropriately housed in the women's facility being transferred to the men's facility. There's no doubt that what's going to happen when they arrive, as it happened to Rachel Doe, that they'll be seen and recognized as a woman, and many of them are indistinguishable from other women. So that distinguishes them.
I think that many of them, the assertion hasn't been, and I don't mean to quibble. I honestly don't. It's just that I don't know. I saw in your brief that you say that 6 of the plaintiffs appear indistinguishable from other women, and that there's no reason to doubt that. And what that suggested to me that it's not the same degree for the entire plaintiff class. But you're right, of course, that being in the women's facility is definitely true of all 19 of them. And if that's the criterion, then can I just ask, would that be true regardless of the reason that an inmate is assigned to a women's facility, that the mere fact of being transferred from a women's facility to a men's facility, regardless of why the person was in the inmate was in the women's facility, that would still be enough to state a constitutional claim?
Well, as I said, it puts a target on them for sure, and it designates them in a different way than any other transgender woman in a men's facility would be seen or recognized by others in the facility. And so that is unique to this
Is that the
for
theory
sure.
then? It's that any trans woman who's in a women's facility is targeted upon transfer to a male facility, and that's all at that point, that's all you need to know.
Well, what I want to say is there could be circumstances, for example, for the broader question, if BOP were to wrongly designate someone for being housed in the women's prison. So it's not as if what defendants argue that there's no circumstances where there couldn't be because of an incorrect assignment or designation. But BOP has created a circumstance in placing someone in a women's facility that puts them at a unique and a different risk than anyone else that is a transgender woman in the men's facility. I did want to say, defendants have not put any facts in the record to describe the 1,455 individuals that are housed in transgender women in the men's facility. And so what was in front of the district court was very specific facts about these individuals. And while not all of them have had genital surgeries, all of them have been on female hormones for an extended period of time, female breasts. I mean, look like
They didn't testify.
they submitted
Affidavits, right?
there's extensive affidavits.
Where they're Has there been any discovery?
There hasn't been any discovery.
Has there
Your Honor.
been anything that's gone on in terms of evidentiary hearings between the time that Judge Lambert issued a preliminary injunction and the 90-day period expired? Did anything happen?
There has been supplemental affidavits in the record, and there's been an opportunity for the.
My question is,
Sorry, Your Honor.
you know, I'm looking toward whether there were any proceedings that were leading to converting the preliminary injunction into a permanent injunction, which would require, it seems to me, evidentiary hearings and some discovery. And my question is whether anything of that nature occurred during that 90-day period.
There were no evidentiary hearings.
Can you point me to where that Judge Lambert took into account the individual circumstances of the plaintiffs?
I mean, yes, and we would go through the 6 orders because, I mean, the other point that I want to make is that the defendants create the perception that there was, you know, a uniform evaluation of each of these individual circumstances. And I'm happy to go through the individual orders, but this was a case initially filed in Doe by 3 individual plaintiffs, including evidence to support the allegations, opportunity for defendants to rebut it. There were then 9 individuals that were added to the Doe case, and then an additional 2 that were transferred when those injunctions were enforced. The Jones case was initiated by an individual who has had genital surgery, was transferred from a low security women's prison to a medium men's facility where, I mean, she was immediately at risk and threatened. She was quickly transferred back. There were then 4 additional plaintiffs and additional evidence before Judge Lambert. So I can walk through those 6 orders, but Judge Lambert was pretty specific in each of them about the circumstances of Maria Moe, for example, and the additional plaintiffs in Doe that had experienced prior violent history in the men's facilities. And so it's
So the way to encapsulate his rationale in your perspective is that the district court took a look at the individual circumstances of each of the 19 plaintiffs and made an assessment that because of their individual circumstances, transferring them to a men's facility presented an unreasonable risk of physical harm.
Yes.
That's the way you read what Judge Lambert did.
In the 6 orders.
Mhm.
And the defendants have had, extensive opportunity to supplement the record. As Judge Clark pointed out, what they've pointed to are generalized statistics that Judge Lambert specifically said were unconvincing because they don't look at the risk of violence that a transgender woman transferred from a women's facility into a men's facility would face. In fact, they don't look at, disaggregate at all the risk to a transgender woman in those men's low security facilities. What they point to is really one statistic of sexual assaults for men in those facilities over the past year, which disregards the facts that the district judge evaluated in terms of and identified in the multiple orders that he issued in terms of the Bureau's own statistics, as I said, in terms of the individual experiences of violence that either individuals faced, or the fact that, Maria Moe, as I said, the first Jones plaintiff, I'm sorry, Jane Jones, they were remitted to the women's facilities of Bureau of Prisons because the judges that evaluated the placement determined that they wouldn't be safe in the men's facility. So there was very extensive record evidence in front of Judge Lambert in making the determinations that he did.
Then am I understanding the theory correctly then that it may be for somewhat different reasons across the 19 individuals, but what they share in common is A, they were all assigned to a women's facility and were in a women's facility. And B, there are other considerations with respect to each of them that renders them particularly vulnerable if transferred to a male facility. The particular characteristics might be different across each of the 19 of them, but for one reason or another or some combination, each of them has characteristics that render them particularly vulnerable. And Judge Lambert focused on the individual characteristics across them to make the conclusion that each of them is vulnerable enough that they state that they have an Eighth Amendment violation were they to be transferred? That's the way you understand
Yeah,
the PI and the way you're defending it?
yeah, yes, Your Honor. And I would add to that, of course, that under the Prison Rape Elimination Act, the Bureau of Prisons has to do a review every 6 months. And so it's not just that they were, I mean, all of them were assigned there, and the Bureau of Prisons, and Judge Lambert does address this, has reviewed those and determined that that these were the appropriate placements. And I say that because the defendants have raised that there are, individuals who were placed in the women's prisons because of a judicial order or because of a need for surgery, for example. That surgery, one of those surgeries has actually been performed. So now, you have a woman who's uniquely vulnerable from a women's facility to be transferred. So yes, the district judge made that individual determination and also said that it's the required non-discretionary transfer that requires the Bureau of Prisons to ignore those individual safety risks.
Was there any evidence introduced with respect to the reaction or distress of the women having biological men among them?
There's no evidence of that in the record
No
here.
evidence.
There's no evidence of the record.
There is a case on that, though, isn't there? We had an intervention motion by, I think it was a woman prisoner who had litigated and we denied the motion, by the way. But I think it was in Washington State or something. Are you familiar with that?
I know that there was a motion to submit an amicus brief, and I reviewed it quickly because I understand it was just filed yesterday. I mean, many of the.
Oh, that I don't know.
Oh, I'm sorry then. I thought that's what you were referring to.
No, this was a while. Okay.
But if I may, there is no evidence here that defendants have put into the record about any problems in those facilities. Yeah.
For exhaustion purposes, am I right in understanding that your theory is that, and this goes to the merits too, but your theory is that there's nothing that could be done in a male facility that could prevent the constitutional injury?
That's correct, Your Honor, that there's nothing that can, well, first, there's nothing that can be, there was nothing to exhaust because the defendants agree that the transfers are dictated by the executive order and that government lacks any discretion other than to transfer them. But yes, that based on the evidence that was in front of the district judge, there's nothing that can be done to keep these individuals safe. And as I said, that was demonstrated when two of these individuals were transferred. And I want to say that the record evidence that was submitted in response to that actually corroborated the allegation of the sexual threat that was faced by Rachel Doe. And what the response was that the BOP couldn't identify the perpetrator, which just suggests and really underscores the risk to them.
To clear this up, at least in my mind, your argument is based on the transfer of a biological male to a male prison, right? From a female to a male prison.
Yes, your argument that.
So how does that affect intake? I mean, the regulation that's mentioned in the executive order is basically a regulation dealing with assessment of people that have just been convicted. So how does your argument affect intake? There's a missing link there. I mean, your argument depends on having been housed in a woman's prison, but a new prisoner, and there must be new prisoners coming every day, every week. I mean, we've got, what is it, 1.5 million prisoners in federal prisons and another 2.5 million in state, because this affects state prisons too. So how does your argument affect the intake?
Well, as because you pointed out earlier, the requirement under the PREA regulation that the executive order overturns would have required an individual assessment that considers either the placement in either facility.
So I mean, hypothetically, the assessment's done, they get placed in a women's prison for 1 day. And now all your arguments click in. They have to be transferred immediately to a male prison.
Well, no, Your Honor, as I was saying in response to the Chief Judge, if there's an error in the determination of placing someone in the women's prison, then that would be a circumstance where, you know, there could be a different determination made if it's made consistent with the PREA factors. But if someone is put in a women's prison because they are identified as being unable to be kept safe in a men's prison, then as I said, it puts a target on them for sure if they're transferred to a men's facility, because the BOP, assuming they've done the assessment correctly, has said that they would be at risk in men's facilities. So it certainly creates a heavy burden to demonstrate after making that determination that they could be made safe.
Can I ask you about one hypothetical situation? So suppose that the reason that an inmate is assigned to a women's facility is not that it's based on a assessment of dangerousness as such, but it's based on something like proximity to family and for visitation purposes. And a judge makes a recommendation for that reason, and then the BOP takes that into account and says there's trans women in men's facilities, there's some trans women in women's facilities. In this particular case, it makes a special sense to put this person in female in the women's facility because of proximity to family for visitation purposes. In that situation, would the transfer under your theory of the constitutional violation, would it create an Eighth Amendment?
Well, as you pointed out, that would go to the merits of the Eighth Amendment challenge. And if it ignored the increased risk that was put upon that individual because of having been in the women's facility, what would be constitutionally prohibited would be to ignore that safety risk and then just reflexively do what the executive order requires the Bureau of Prisons to do, is to ignore the safety risk. And so that could create constitutional implications in that individual case.
So you describe the risk of these transferees showing up in a male prison. How do the other prisoners know where they're coming from, who they are? Presumably they give them different prison garb and they allow them to groom differently. I mean, I know there are things, but you were saying sort of apart from their individual characteristics, how they present, the hormone treatment and other attributes of them personally, that the travel from facility A to facility B would, I think you said, put a target on them. I'm not sure I know enough about the information around these actions to appreciate that.
Yeah, I mean, the reality is that there's a lot of information flow across the prison system, and that information will be quickly known. In these cases, actually, what happened was that the facility refused to provide bras, for example. And so it was, obvious and apparent to everyone that these were individuals who had cut. Well, this isn't in the record.
It seems like it's obvious that their body is what their body is,
Yeah.
not so much where they've come from. If you were a newly incarcerated person and you had the same, garments issued to you with the same limitations, you'd be vulnerable for that reason as well, no?
Wait, I'm sorry, I want to make sure I understood your question. The last part of it, that you would be.
Just
Oh.
if you were newly arrived, not transferred, you'd never been in a women's prison, but you're a trans woman
Oh.
with developed breasts, and outside of the facility, you're used to wearing a bra, and you go in, they don't give you one. It doesn't seem to me that it's having been under the prior regulation assigned to a women's facility that puts that target on your back.
It's not exclusively that, for sure. And that is, that any individual other transgender women that applied would also be
Isn't there,
and sexually victimized.
Who's
aren't there
burden-
regulations dealing with that? I thought there were regulations, like they have to provide separate showers. Isn't that in the regulation?
Yeah, yes, Your Honor. Yeah,
Yeah.
so there are other ways in which
And-
they would be treated
And I think-
differently and designated.
And I
identified.
think I read that they have to, that the prison authorities in a male prison have to provide females who, or males who have had breast surgery with bras.
There, I mean, this executive order purports to overturn the requirements and, I mean, in
Well,
fact,
it
people were
doesn't-
denied
it doesn't-
when they were
It
transferred.
doesn't deal with the
bras.
separate showers. Or the
No,
other
I agree with
things.
that, Your Honor. I
Yeah.
agree with that.
I thought that part of the PI isn't being appealed by the government.
It's not.
Okay.
It's not.
Can I just follow up on Judge Pillard's
Yes.
hypothetical? So in the situation in which a new inmate shows up in a male prison and presents as a woman, that could be because they're a new inmate. It could be because they're transferred from a women's facility. It could also be because they're transferred from a men's facility because
Yes,
people
Your
get
Honor.
transferred for other reasons. And so in that context, the inmate could be in the male prison for any of those reasons. Is it, what's your view in that situation? Because I heard part of your answer that, well, they're in danger because of their female features.
Yes, Your Honor.
And that may well be true, but then if that were true, then why doesn't your theory then cover all trans women inmates who are in male facilities now? Regardless of whether they came from or transferred from a women's facility, that then it seems like it would potentially cover the full sweep of the 1,448, whatever the number is,
Right.
which is something that you're disclaiming your theory does.
So this case has been brought on these 19 individuals.
Yep.
Judge made factual findings on that basis. It may be that there are, I just want to say, of the 1,455 individuals who are facing Eighth Amendment violations, but it's not the executive order's requirement of them to be transferred that's applied to them. And so the constitutional question associated with that doesn't apply to the individuals that are currently in the male facilities.
But so your theory could cut, I guess, I just want to make sure I understand. Is your position that your theory actually doesn't cover all 1,400 plus, or is it that all 1,400 plus aren't part of this case because they haven't been transferred? That's definitely true. And so we just don't need to address them. I took your brief to be taking the position that your theory actually doesn't cover all trans women who are in male facilities. But maybe I'm just.
Well, the district judge in this case evaluated each of these 19 individuals and applied the Eighth Amendment standard to make a determination that they are, that the Eighth Amendment standards apply to them. And among the factors that he would consider is the past history of the BOP designation and the predictable experience that they would face if transferred.
And I guess, I mean, as you mentioned before, we don't have information on the characteristics of those 1,500 odd other trans women in BOP custody. There may be people who are very able to, forgive my nomenclature, to pass, as men, they're trans women, they can come into a prison population and present themselves in a way that people would not mistake them for women or would not think they look highly feminized. And we just don't know.
We don't know, Your Honor. We don't
But-
even
But
know.
you're also not disavowing the possibility that there may also be people who, under the PREA regulations, were assigned, trans women who were assigned to a male facility and who may in fact be running into serious harm or risk of harm in that facility and may have, PREA regulation or not, executive order or not, may have an Eighth Amendment claim. And then there's a question, if they repeal the PREA reg, what's available to them, but that's not this case.
Correct, Your Honor.
Whose burden, this is going back to exhaustion, and all these questions about, depending on how you read the interaction between Ross and Booth, under Booth, if there's some relief that BOP can offer from the action complained of, whose burden is it to show that either there is no relief that BOP can offer or that there is some relief? Is it the plaintiff's burden to show no relief, or is it BOP's burden to show there is some relief?
Well, here, there's no question that there's no relief.
So there seems to be some dispute, at least at the level of the briefing. I'm not sure in the record, but, let's say they had in the record said, we can give people door locks, we can put, station guards near the area where they are housed, we can, isolate people who are aggressors. There's a whole bunch of things that we can do. We do really quickly. We have emergency exhaustion. You need to exhaust. Let's say that is all true, but it isn't in the record. Whose fault is that? Is it the plaintiff's fault for not having excluded it, or is it BOP's fault for not having said, look, we can do all these things?
I think it's on the defendants who haven't put evidence in the record to show that they can, ensure that.
And do you have any cases that would so say with respect to this burden about exhaustion under the relevant provision?
Your Honor, I don't, but I would also urge this court to look at the amicus brief that was submitted by the law professors on the position regarding exhaustion, because there are multiple pathways in this case to address the exhaustion issue, including the fact that these individuals were told that they couldn't exhaust because BOP had no discretion other than to make the transfers, and because of the timing that prohibited them from getting any relief, including, 3 of them at least having been immediately transferred and others being prepared.
Yeah, that is a helpful brief on the issue.
Can I ask you, do you have, I know this just came up in oral argument, but do you have at least an immediate reaction to follow up on Judge Randolph's question about the provision that says that a preliminary injunction can only be in place for 90 days?
Yeah, my response to that is that what 3626 specifically contemplates is the anticipated renewal of an injunction in 90 days. And Judge Lamberth, tracked the requirement under 3626A2 that authorized the renewal on 90 days upon the court making the required findings around the PLRA factors. I'm not familiar with the case. We would ask for an opportunity to respond to it.
The purpose of that provision, according to the committee reports, was to accelerate any lawsuit that dealt with prison conditions and rights of prisoners, because some of those cases were dragging out for years and years. And so the purpose it's pretty clear. I mean, there's a Supreme Court case called Rufo versus Suffolk County or something that you may know. And the provision says that once you put in a preliminary injunction, it can only last 90 days unless, et cetera, is converted to a final injunction. To say that this is just being renewed is, to my mind and to the 11th Circuit's mind, a complete refutation of the purpose and the language of this statute.
I just have a hard time truing that with the language of 3626A2 that anticipates the renewals.
A preliminary injunction shall expire automatically, unless what? Unless a final injunction is issued.
And makes the order final. There's that.
I understand, and I will say that the defendants have not even objected to 2 requests for renewals and the renewal of those, along with the specific PLR.
We're talking jurisdiction and probably mootness as well. It doesn't matter that they didn't object.
I think there's a circuit split on it, but we can look into it.
Yeah. Wondering if you had an immediate reaction to something that candidly just came up in oral argument. So I appreciate it.
Thank you.
So you do I was pressing you on whose burden it is. That you do cite Supreme Court's Jones versus Bach, which says this is an affirmative defense, which typically means it would be the defendant's burden, certainly to raise it. But then there's some circuit law elsewhere, not in this, that says, you know, when it's raised that there is exhaustion, then question whether it's impracticable. You know, the circuits differ on how that's parsed. So there is a statistic, and I guess I want to ask the government this too, maybe on rebuttal, but there's a statistic saying that the low security men's prisons where these plaintiffs would be proposed to be transferred are safer than the women's facilities. But I did notice, I don't know whether you raised this, but that includes assaults by staff as well as by fellow inmates. So it would stand to reason that a trans woman going from a women's facility to a men's facility would probably face an increased risk that those statistics do not account for.
Absolutely, Your Honor. Yeah, we agree with that.
Wish my colleagues don't have additional questions. You, Ms. Eli? Okay.
Thank you, Your Honors. Yeah,
You-
nothing further.
Thank you.
Thank you.
Mr. Hayes, we'll give you the 3 minutes you asked for rebuttal.
Thank you, Your Honors. Just a few points on rebuttal, just to hit some of the points that were raised here. So I think one of the points that was raised, starting with this idea that they're unique, plaintiffs are unique because they are in a female facility. I think it's important to emphasize that there was no determination made, and there's nothing in the record to say that the reason any of these plaintiffs were in the female facilities is because the BOP made a determination that this is the only safe place that they can be housed. And the district court recognized that. He said in one of his opinions, it may well be there's a variety of circumstances, and that's true because it's a multi-leveled analysis that, you know, and so at this point, and the Stover Declaration say this explicitly, there is nothing to suggest, no evidence that safety was the determining factor, or that the Bureau ever said determined that these plaintiffs could not be safely housed in male facilities. There was some discussion about the plaintiffs being uniquely susceptible to harm because of transfer. I am unaware of any evidence to suggest that supports the idea that mere transfer from a female facility to a male facility, as opposed to the other scenarios Your Honor mentioned, coming in initially from one male to another male facility, no evidence that I'm aware of to say that that puts them at any sort of increased of risk of harm at all. There's some discussion about, I think.
It's not in any, as far as you know, in any of the affidavits that there's the prospect of targeting because of a transfer from a women's facility.
No, I'm not aware of that. So their affidavits don't address, a lot of that address hormones, which is not an issue in this case. And the one that's on point, I do not believe mentions that whatsoever.
When you say there's nothing in the record saying that they couldn't be safely housed in men's facilities, I thought you just said that. You look like
that they can't be safe. No, what I said is there's nothing in the record indicating that the Bureau determined they had to be housed in female facilities to be safe. And so, yeah, okay, maybe I understand.
You said there's maybe what you said was the BOP did not make a determination that they could not be safely housed.
That's
in
correct.
men's facilities. I guess that's different from saying there's nothing, because I think there's a lot in the record showing that they can't be safely housed in men's facilities. Indeed, the declarations, their history of sexual assault and rape in men's facilities, and the experience of the women who were briefly transferred from women's facilities to men's facilities and brought back is, I mean, you can quibble with how powerful it is on the merits, but there is ample evidence that they have not been safely housed, and they have been in men's facilities.
Well, so I think what the relevant sort of level of analysis here isn't men's facilities generally, because that of course would include high security men's facility where murderers and rapists are housed, and that's a very different world. I think the relevant point that we need to look at is which facilities and the particular facilities that the Bureau has designated for them here. And that information is in the record. Stover declarations lay it out. And there's a lengthy chart attached to, I believe, the second declaration in the Jones litigation, which lays out statistics on guilty findings of assault generally, and then breaks it down based on sexual assault, which is sort of lower level sexual assault or high level, and so on. And I think those statistics are very revealing. So each one of these facilities, first of all, is a low security facility, which means nonviolent offenders are housed there. So this is not where other violent individuals who would be more at risk of being perpetrators are housed. So that's point number one. In this,
On your point number one, in fact, isn't there a requirement that the Bureau of Prisons or the Attorney General submit a report to Congress every year with respect to rape and sexual harassment in federal prisons? I think there is. It's under
I trust you on that.
It's under
Yeah.
Prison Rape Act. And I ran the numbers, and the last numbers I saw were 2023. And at that time, it was about 1,500,000 federal prisoners. And the incidence of rape or sexual harassment was 0.5% of the population.
So one of the things I wondered about is you do, I think repeatedly in your brief refer to, or maybe it's also in the declarations, refer to the facility, the target facilities, the low security men's facilities, you characterize as having lower incidence of assault or sexual assaults than the women's facilities. And that surprised me. And so I looked into it a little bit more, and I think in the society at large, the women are more victimized of sexual assault more frequently than men, and men are more frequently the perpetrators. So the notion that if you had a women's prison that people would be more frequently victimized by sexual assault surprised me. But the figures include victimization by staff. And that makes me think that if you put a woman in a transgender woman in a male facility, she may not have reason to take much comfort from the relatively low rates of assault there.
So the information I'm aware of that was attached in the Stover declarations, I don't know if Your Honor is referring to that Bureau of Justice statistics report. I'm referring now to like the data specific to these facilities, which I was a little surprised to have us be criticized for referring to sort of generalized data. That report is the only basis on which the district court relied, the only basis. So anything that the plaintiffs may say against that report in terms of the statistics not being disaggregated and so on is a problem for them. It's their burden, not a problem for us, because what we rely on is the information that Mr. Stover submitted, which lays out the guilty findings of assault for the facilities in which the plaintiffs are currently in compared to the ones in which they have been designated for, and they are lower.
All I'm saying is we don't know the most salient thing, which is how do the low security men's facilities deal with transgender women being there? And it just stands to reason, and especially since there's past experience of some of these women, including in low security men's facilities, being victimized.
So I disagree with that because every single one of these facilities to which plaintiffs has been designated currently have trans-identifying men in them. So these rates, which are
We don't have that information. We don't have that broken down.
I don't know what you mean.
How many?
Oh, how many?
Where?
No, I think we do. I mean, so we have. I don't know if I can specify certain facilities because some of that might be under seal.
Right.
But
But we do have information of in a low security men's prison,
which they've been
how many
designated.
of the residents there are trans women?
This is in the Stover declarations. Yes. And so I think that's important because, number one, and to your point, it shows that looking at the very low rates in these prisons of sexual assault, that's not because they don't have this particularly vulnerable population in them. It's despite of the fact that they do. right? And they are still that low, which I think speaks to the point that this, can't be a substantial risk of harm that is objectively intolerable when you have one guilty finding of assault across all 7 prisons in 2024. And that's not an anomaly at all. From 2020 to 2021, 0. I think 2022 had 1 in 1 facility, and then so on. Those are the numbers. And it's just very hard for me to say, to think that that can rise to level an objective risk of serious harm when those are the numbers. And it also goes to show that these are facilities that are well aware of how to manage prison populations that have trans-identifying people in them, and therefore they are accustomed to knowing what issues might arise and how to address them. I see my time has expired. Thank you, Your Honor.
Sure my colleagues don't have additional questions.
Do you have anything about the burden not being on the BOP to show that there is some relief that exhaustion could provide?
So
It's clearly on the BOP to raise exhaustion as an affirmative defense. Once you've said, look, we have an exhaustion process, to the extent that there's dispute about whether there's anything that can be, any partial relief that can be provided through that, is it your burden to establish that there is some relief, or is it the plaintiff's burden to negate that there might be some relief?
I don't know the details of that. I do know that it's an affirmative defense, but beyond that, I'm not sure how this court or others have worked it out. If you
I don't think we have anything directly on point.
Okay,
but there is-
I haven't seen a case that addresses that.
All
But I mean,
right.
if you would like, we can submit a 28J on that question. We could also submit a 28J on the 11th Circuit jurisdictional question, if you so direct. Thank you.
Thank you, counsel. Thank you to both
Very
counsel.
helpful. You might as well go ahead and submit. You said if we so direct, I'm just,
On both of those?
Yeah.
Sure.
Thank you,
Thank you.
counsel. And if we want supplemental briefing, we'll issue something on that. Thank you, counsel. Thank you to both counsel. We'll take this case under submission.
This honorable court now stands adjourned until Monday, September 8th at 9:30 a.m.